So, is there a golden rule for lawfully obtaining documents from a workplace?
Yes. So in the rules book, so first off, documents is the difference between beginning, losing, and winning a case. Your word might be great, but the government is always looking for documents. And if you get fired, people are going to be looking at documents, emails. What's your proof? How can you prove there was retaliation? How can you prove there was wrongdoing? And documents, emails, and all that are really at the foundation. So there's a tension between the need of the whistleblower to obtain documentation and rules that prevent whistleblowers from removing documents from work. So you can then divide this into two separate evaluations. The first is if you get fired and the company accuses you of improperly removing documents from work. And they can do that either as a justification for firing you or a justification to smear you before a court, or something known as after acquired evidence justification to prevent you from coming back to work ever. And the courts have a balancing test. They have 6 factors they look at. They're all discussed in the rules book. So if you look at those factors, you can pretty much gauge whether you can remove a document or not and still win an employment case. The second is a much more interesting issue, and it again shows the strength of the reward laws. So now let's assume you're acting essentially as a confidential informant at work. And your goal is never to be identified and never have an employment case. So those rules governing employment cases kind of fall aside. And now it's like, can I remove a document to give it to the police? So an analogy I like to use is you go over a friend's house and there in the newspapers, there's all this stuff about someone killing people with a knife. And you go to the restroom and there you see in the sink a bloody knife. I mean, what do? And if you were to very carefully put that bloody knife in your pocketbook and go and give it to the police, would that be theft? You can see when you're trying to give evidence of wrongdoing, of a crime, to the police, there's obviously a different evaluation. And this distinction goes back well over 100 years. So the bottom line is as follows. A citizen can take information and documents that the government would need a search warrant to take, but the citizen can take it without a search warrant and give it to law enforcement. Now, in this context, if you give it to the newspapers or to your cousin or whatever, you're in a different world. This is essentially to give it to law enforcement. Second, there's something known as the zone of privacy. So this is the difference between hacking, but if you're at work and you have lawful access to information, then you can generally take that information to give it to law enforcement. It's the right of privacy. If the company is giving you access to materials, it means the company has essentially waived its right to privacy to those documents. And they should expect that if you see a crime, you report it. But on the other hand, you can't break into your boss's office. You can't access information for which you have no access to, no right to look at. And that's kind of how the courts have been looking at these cases. These are very difficult issues. And I radically suggest speaking to a lawyer before you remove documents, because you can even start doing it in conjunction with the government. And then you're very much protected.